you onto this program. We ask for open eyes, open ears, minds to comprehend, and Lord, just anoint Cipriano as we listen to what your Spirit is going to teach us about our American history. And we just give this program to you in the name of Yeshua Jesus. Amen and amen.
Amen. Cipriano, you've been going through the amendments. What do you have for us tonight?
We're actually going to go to Amendment 9 tonight. So we've gone through the amendments. The key I always like to share about is why I go through these things and how they came about. You know, there's a reason why we have the Declaration of Independence, the Constitution, and the Bill of Rights. We go back, and the wonderful thing about this whole thing that establishes part of this whole thing, when we go back and look at the Liberty Bell. Well, on the Liberty Bell, there is an actual inscription on it, and it actually is from Leviticus 25:10. And so I'm going to just go ahead and ask you to open up the book and go to Leviticus 25:10 when you get a chance and see what it actually reads. It's actually on our Liberty Bell. You know, we talk about the Declaration of Independence, and we talk about in there it says that we are endowed by the Creator with these rights. It doesn't say governments, it doesn't say man, it doesn't say corporations, it says by the Creator. And these are the fundamental things. Once we start grasping that idea, we'll see why America was blessed. Now, what happens when we don't follow those things, the blessings don't come because we're not doing what God has asked us to do. And I love what the previous program is. Folks, this is a choice. You know, you can choose to be in sorrow and in torment and stay there all your life if you choose to. But if you seek God, you will find that the joy of the Lord is your strength. You will find happiness, joy, and peace. This is the gift of this whole thing. So we're going to go into the clip on the amendment. So here we go. So let's go for it.
Today we're learning more about the Ninth Amendment to the U.S. Constitution, which reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." This, along with the 10th Amendment, doesn't protect a specific right, like freedom of religion or due process under the law, but rather advances an interpretation of the scope of the Constitution and of government power. To learn more about the Ninth Amendment, I talked with two experts. Kurt Lash is the E. Claiborne Robbins Distinguished Chair in Law at the University of Richmond School of Law. Jeffrey Rosen is the president and CEO of the National Constitution Center. He's written extensively on the history of the Supreme Court. Professor Lash, can you tell us a little bit more about this amendment? Why did the framers include this amendment in the first place?
The Ninth Amendment, like the rest of the Bill of Rights, was added at the insistence of the states. Although the advocates of the proposed Constitution had claimed that the national government would have only limited enumerated power, the state ratifying conventions wanted that promise put in writing.
Originally, the Constitution didn't contain a Bill of Rights because James Madison said a Bill of Rights would be unnecessary or dangerous. Unnecessary because the Constitution itself was a Bill of Rights. It only granted Congress limited powers, and therefore Congress had no power to infringe free speech, for example, or religious liberty, and therefore wouldn't be able to do so. And dangerous, Madison said, because if you had a Bill of Rights, people might wrongly assume that if a right wasn't written down, it wasn't protected. But in response to objections by anti-federalists, that is, those opposed to the ratification of the Constitution, led by George Mason of Virginia, as well as Edmund Randolph of Virginia and Elbridge Gerry of Massachusetts. So those three guys said, hey, unless we include a Bill of Rights for greater security and safety, then we don't think the Constitution should be ratified. And in response to their objections and those in ratifying conventions, many of which demanded a Bill of Rights, Madison changed his mind. and he included a Bill of Rights, which he cut and pasted from Revolutionary era state constitutions. And viewers and listeners can check those out at the Interactive Constitution. But then that raised an interpretive problem. Madison and others were worried if you just had a limited list of rights, 10 amendments in particular, protecting particular rights, people might assume that if a right wasn't written down, then it wasn't protected. And the framers didn't want you to reach that conclusion because they believe that our rights come from God or nature and not from government. Thomas Jefferson in the Declaration of Independence said we're all endowed by our Creator with certain unalienable rights.
And when you look at these amendments, our first 10 amendments, you'll notice that some address specific issues like speech and the right to bear arms. The last 2 amendments on that list, however, address broader issues of constitutional interpretation. These are rules of construction. The 10th Amendment declares that all powers not delegated away remain under the control of the people in the states. The 9th Amendment addresses the problem potentially raised by adding this list in a Bill of Rights. The 9th Amendment tells us that just because the Constitution lists certain important limitations on federal power, this doesn't mean that the federal government has otherwise unlimited power, or, as the 9th Amendment puts it, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage to others retained by the people. And in this way, those 2 last rules of construction ensure that every subject not placed under the control of the national government would remain under the control of the people in the states and remain there as a matter of right. These amendments protect the people's retained right to local self-government.
So I've talked a bit about natural rights because that same notion of the idea that you retain natural rights when you move from the state of nature to the civil society is picked up in the language of the 9th Amendment, which says that the enumeration of certain rights shall not be construed to deny or disparage others retained by the people. So one big theory of the 9th Amendment is that it refers to these natural rights that come from God or nature and that you retain during the transition from the state of nature to civil society.
All right, so can you give us a few examples of what those unenumerated rights that people have debated have been?
The paradigmatic source for identifying what unenumerated rights are protected is a case called Corfield versus Coriell. It was decided in the early 19th century, and it was cited repeatedly by the people who wrote the Privileges or Immunities Clause to the 14th Amendment to the Constitution. And basically, the Privileges or Immunities Clause says that no state shall abridge the privileges or immunities of citizens of the United States. And the question is, what are those privileges or immunities? And in trying to define them, John Bingham, who wrote the 14th Amendment, and a lot of other people said, well, some of the privileges or immunities include the rights written down in the Bill of Rights, but others are not written down in the Bill of Rights, and you can find them in the Corfield and Coriell case. They're rights that are fundamental, they're uniform from state to state, and they've been considered basic rights of Americans from the beginning. And some of these rights include the right to make and enforce contracts, to sue and be sued, to have basic economic rights, and also to have the benefit of the writ of habeas corpus, which is in the original Constitution, and that's the right to challenge the constitutionality of your conviction. It's in the original Constitution, but not in the Bill of Rights. So those are just some examples of the unenumerated economic rights that the framers of the 14th Amendment considered to be protected by the 14th Amendment, and then by implication by the 9th Amendment too, because they are natural rights, as we heard Roger Sherman say, the basic rights of acquiring and possessing property and obtaining happiness and safety. Those are some of those rights.
The 9th Amendment raises the difficult issue of how exactly you determine what the rights are that are actually retained by the people. And the text of the 9th Amendment itself tells us very little about the specific content of our retained rights. But in fact, these retained rights are as numerous as the stars in the sky. They include everything from wearing a hat to walking on the sidewalk to purchasing life insurance or determining where you can park your car or what classes should be offered in the local high school. Basically everything that was never meant to be handed to the control of the national government. All of these are rights retained to the control of the people in the several states. And all of these rights will be protected if you limit the scope of federal power. A limited interpretation of the Commerce Clause, for example, preserves the people's retained right to establish local educational policy and to pass all manner of local civil rights legislation that's not expressly covered by the federal Constitution. The greater the limits on federal power, the greater the freedom of local communities. And by making a limited interpretation of federal power a right, this ensures the matter can be litigated in federal court and not just left to political compromise. Over time, courts will produce a body of law that invalidates attempts by the federal government to regulate our lives in forbidden ways, such as not having the power under the Commerce Clause to force us to purchase private health insurance, or not having the power to commandeer state officials and force them to enforce federal immigration policy.
Does this refer back to some extent to kind of the common law of England and the things that were considered the natural rights of Englishmen?
Yes, it does. Although we should distinguish, if we're going to be precise, which we should, not all of the common law rights of Englishmen were natural rights. The common law rights basically are rights that were traditionally protected by English law. They're rights that had been recognized by English judges over centuries. Natural rights come from God or nature, not from government. And there's overlap between those groups, but there might have been some common law rights of English people that were recognized by tradition, like the right to jury trial, for example. It's not a natural right because there are no juries in the state of nature. They're just people who are, imagining forming governments. So it makes it a little tricky, but it's actually not that analytically tricky. And it's so interesting that over and over again, the framers said, this is just, everyone knows what these natural rights are. They're the ones that are recognized in Corfield and Coriell. They might, and then other enumerated rights might include the common law rights of Englishmen. But it was a pretty short list. And the best way to just figure out which rights were natural, go to the interactive Constitution, click down and look at those. Look at the Virginia Declaration of Rights. Look at the Massachusetts Constitution of 1780, the New Hampshire Constitution, which has this beautiful preamble about what a natural right is, and you'll just see that all of these state constitutions are recognizing the same natural rights over and over again.
So has the Supreme Court ever decided a case based on the Ninth Amendment?
The first judicial opinion was actually written by Justice Joseph Story, one of the most famous justices in American history. In his opinion in Houston against Moore, decided in 1820, Story explained that the spirit and letter of the Ninth Amendment called for the limited interpreting of the scope of federal power in order to avoid interfering with state laws regarding the local militia. In fact, it wasn't until the 20th century that you find scholars and justices trying to invert the Ninth Amendment in a manner that allowed or even required federal interference with local policies. In Griswold against Connecticut, for example, Justice Arthur Goldberg argued that the Ninth Amendment supported the court's invalidation of state contraception laws.
Douglas says in this case that the Constitution and the particular rights in the Bill of Rights include certain penumbras formed by emanations from the particular guarantees that may create broader unenumerated rights. And privacy was one of them. Douglas says privacy is protected in different ways in different parts of the Bill of Rights. The Fourth Amendment protects our right against unreasonable searches and seizures. The Third Amendment protects the right not to have soldiers quartered in the home. The First Amendment protects the right of freedom of association. And from these particular expressions of privacy, Douglas extracted or inferred a broader and more sweeping right of privacy, which could be extended to cover a married couple's right to use contraception.
When the Bill of Rights was ratified in the late 18th century, it only applied to the federal government. It was not until after the Civil War in the late 1860s, early 1870s, that the 14th Amendment applied some of the protections of the Bill of Rights to state governments. So how does the 14th Amendment impact our understanding of the Ninth Amendment?
Most constitutional historians believe that the Privileges or Immunities Clause was originally understood as applying the first 8 amendments against the states. But what of the Ninth Amendment? Is it possible that the Privileges or Immunities Clause turns the Ninth Amendment from a provision protecting local government to one that interferes with local government? Many libertarian scholars believe so. A close look at the historical record, however, shows that this is not likely. To begin with, John Bingham, the man who framed the Privileges or Immunities Clause, publicly declared to the House of Representatives that the Privileges or Immunities Clause made the first 8 amendments enforceable against the states. He said nothing about either the 9th or 10th Amendments. Meanwhile, in the Senate, the man who introduced the proposed 14th Amendment to his colleagues, Jacob Howard, also said that the Privileges or Immunities Clause would apply the first 8 amendments against the states, and he too said nothing about the 9th or 10th Amendments. And finally, the public that debated and ratified the 14th Amendment remained broadly committed to the Federalist principle of dividing power between the state and local governments. It had been the slave-holding rebel states that had violated this principle by demanding that slavery be enforced throughout the nation, regardless of local freedom laws. If we look at the period in which they adopted the 14th Amendment, it appears that that amendment did in fact apply the textual rights of the first 8 amendments against the states, but it left everything else to local control, subject only to the requirements of due process and equal protection.
Well, the Ninth Amendment, at the very least, is a question of interpretation. It says, don't assume that if a right isn't written down, it's not protected. So when Robert Bork, the late Robert Bork, who was nominated to the Supreme Court in 1987, but didn't get through, said that the Ninth Amendment should be treated as an ink blot because we can't know what rights are actually protected by the Ninth Amendment. It should be ignored. That can't be right. That's the one thing that Madison said, don't do. Don't assume that if the right isn't written down, it's not protected. But saying that matter of construction is important and that there are certain rights not enumerated in the Constitution that are protected doesn't tell us which rights are protected. And that's where all of the action and all of the drama and all the excitement and constitutional interpretation in the 20th and 21st century has come from. How do we identify the rights that are not written down or not enumerated but are protected? And there's a whole lot to say about that. And in fact, that's why we teach constitutional law, is to study the methodologies of interpretation that lead people to different conclusions about which unenumerated rights are protected.
So we've learned that the Ninth Amendment served as an assurance that the Bill of Rights was not an exhaustive list of the rights retained by the people or the states. But how can you protect unenumerated rights, which by their very definition aren't named in the Constitution? Kurt Lash sees the original meaning of the Ninth Amendment as a restriction on federal power. Jeff Rosen reminds us that although it's difficult to tell which rights the framers intended to protect with the Ninth Amendment, it's likely that those rights included the same natural, unalienable rights enshrined in the Declaration of Independence.
Alrighty. Now that one was very interesting because that one really puts in place powers and where they're supposed to be in the federal state side. But the key that I saw in it, as it says, retained by the people. I'm reminded that this is a government of the people, by the people, for the people. I don't know anywhere where it says by our servants, for our servants, and we are subject to our servants. I don't see that anywhere. So I'm really, really concerned about that because we're seeing practices of such things that really shouldn't be happening. And that's the key thing about this whole piece about the Ninth Amendment, because when we look at it, we are to look at the Constitution, but also look at what I like what they were saying about our natural rights. And the fun thing about natural rights, when we're talking about nature and unalienable rights, of all the things, the natural rights that we look at is in the Ten Commandments. The Ten Commandments used to be in every courthouse at one time, even in our public schools and our buildings, because that was the fundamental law for us to practice. And so, with that being said, do we have any comments, any other thoughts?
I was going to say something about why do we take out the Ten Commandments from every courthouse? How was that allowed to happen? Seems kind of strange. We see our natural law and common laws, the mixing of them. We see the unnamed rights, difficult to interpret or assess. You know, we let something so basic as the Ten Commandments, the foundation, be taken out of this.
Unfortunately, that was based on Supreme Court ruling, and in the Supreme Court ruling in the 1960s, they said that it was we should take prayer out of schools, and then they started taking things out of buildings. And you know, I remember all the way up into the 80s, almost into the 90s, there was churches that actually still used to meet at public schools. Of course, we don't see that now, but we did. One of the very biggest things that I can talk about public schools or having church in public buildings, it was well known and customary for the Senate to open up the House on Sundays so that they would have church. That was Jefferson had asked for it because a lot of the representatives in town they weren't at their local churches, so they wanted to go to church. So they went to the Speaker of the House and says, "Okay, let's open up the Senate and let's have church," and they did. And that's where they actually start to establish prayer before Congress even does business. Unfortunately, and please keep this in mind, traditionally, the Supreme Court, it's an opinion. The court gives an opinion, but that does not necessarily mean the federal government or the states or any of the individuals need to follow it, because remember, it all goes back to the point that all rights are retained by the people. Now, it's really interesting because there is, I'm trying to think, I think it was Madison, but I'd have to go back and confirm, who actually talked about the jurors being the legislatures, because when laws are done, and if laws are not up to what the people decided should be in the case, the jury has the power and authority to not just view the case, but the law at that time, because that may be a non-constitutional law, which and how it's being addressed. And we're seeing that happen even in our day, looking at certain things. So this is what we need to just actually inform our brothers about, and our brothers and our sisters, that the key thing is that it's real simple. If you do not read it and ask the questions for yourself, then you're not going to know. And so I've had people tell me things about what they thought was in the Constitution and limitations that I knew was not true, but they said it so passionately that because they had not really read it, it's just what they heard, they're passing it on. And it's our duty to know our documents. How are we going to know them if we don't read them? Any other thoughts, comments?
Yeah, I'm with Jim there. The what are they called? Unenumerated rights. Unenumerated rights. And I know that's in legal circles that's really hard to define, because we don't have names, we don't have actual definitions, and a lot of the legal process has to do with defining things and explicitly erecting these visions of what some of these things are about. So that seems to be kind of a stumbling block, doesn't it, Cipriano?
Well, there is a difference between law and legal. She mentioned common law is based on the Ten Commandments. Legal is not. Legal is, it's like, okay, here's the Ten Commandments and here's the goalpost and it doesn't move. Okay? And legal, you can make yes a no a yes, you can make it whatever you want it to be. Once we understand what law and legal is, and the practice of law and the practice of legal, then we can actually start addressing the issues accordingly. But if you are told that just because it appears like a law and it looks like a law and they say it's a law, that doesn't necessarily mean it's a law. It just means that's someone's opinion and trying to convince you to follow what they want you to do. And that's what statutes, ordinance, and regulations are, because you will not find one in the Constitution. The reason why? Because it lacks due process. Why? Because you are innocent until proven guilty. But if you look at a statute, an ordinance, a regulation, it defines it right off the bat that there is a penalty, a fee, or going to jail. Okay? But that's not in our Constitution. See, you can bring a charge in an individual and indict them before your peers, and they're the ones supposed to make that judgment call Because, see, they're the one closest to them and know the character of the individual. Most judges don't really know the character of the individual, but the people did and the communities did, and they talked to one another back then. So we knew that if something happened, it's called, I'm trying to think of it, the term, when something looks like somebody done something wrong, but they didn't do something wrong, it just gave the appearance. But because people knew who they were and knew their character, they could then make the judgment according to their character, not necessarily to what the law says, because of the fact that circumstantial. It may be circumstantial, not necessarily a fact. You know, we do have accidents that do happen, but there are those that will. There's a difference between killing someone knowingly with intent than to actually have someone die of an accident, not something that they intended to do. And there's a difference. And so these are the things that have been muddied in the water here with our legal system. And unfortunately, we need really to get back to our lawful system. We need to continue to practice law, not necessarily practice legal. So it's two different things. I hope I answered your question.
Yeah, I hope you did too, Cipriano. That I think that's part of the issue there. One of the things other than that is when we use the precedent. In law, precedent is what's setting a lot of the legal things right now. And so if they can get it, if somebody can prove a particular point, and maybe the next time somebody proves a little bit more of a point, pretty soon if we don't have the standard, if we don't have the constitutional background, the common law even, then we're going to veer away from the core.
That's actually
what's been going on, isn't it? Yeah.
Exactly. It has to do with how our universities and law have changed. They did once practice and taught law. Now they're practicing and teaching legal. We talk about the supreme law of the land. That's the common law. We talk about other jurisdictions, authorities of laws and actions. Like, for example, common law, then you have statutes, ordinances, and regulations. And the difference in all their stuff is in common law, it is based on the Ten Commandments. All the others, you can, like I say, you can change them, you can do whatever you want. That's a problem. You can make a yes or a no, a yes. And I'll give you the example of what I'm talking about. A lot of times when legislatures create an act, they put in definitions in the act. Okay? Well, in common law language of men and women, we know what a right is. But if they put in a definition and say, well, the definition of right is actually going to be a privilege, which means then that it can be taken away. Okay? Now, if it's in the act, then that means that's part of the definition of whatever it is the enactment is about. But that's not necessarily a true bill. Okay? It may it may look like one, but it doesn't necessarily mean it is one. And these are the kind of differences and things we need to look at. So on down the road, we're going to be talking about law, and we're going to be talking about legal, and about actual what is actually civil law, what is common law, and breaking it down so that we'll have some understanding of what our standing is as an individual or as a corporation, and so on and so forth. So from there, join us. We will keep on going with some more.
Amen. We are just about out of time here, so let's move on a little bit. Hold on.